He was there, I have seen, but then now I cannot see him. अजय जरा देखो मिस्टर जॉन कैबा का है कि नहीं?
Yes, sir. Sir, I joined now.
Hello, can you hear me now?
Yeah.
Okay, great. Good.
Yeah.
Good morning, everyone. I was not able to unmute for some reason, but I'm here. And I've unfortunately been having some technical difficulties, so hopefully you can hear me well.
Okay. No, it's okay. It's okay now.
Okay, good.
And, Kathy, you can start now. Lordship, can we start now?
Yeah, surely. We are on, so let's start. It's already 11.
A very good morning to our esteemed panelists, faculty members, and all the participants who have joined us today. Welcome to the second session of Day 3 on International Conference on Mediation. Without any further ado, I would like to invite Professor Dr. V.K. Ahuja, sir, to deliver the welcome address. Sir is an acclaimed academician and has published extensively in the field of intellectual property rights and international law. Sir is an alumna of Delhi University, Jawaharlal Nehru University, and has completed a certificate course on law teaching and legal research skills from Cardiff Law School of United Kingdom. Sir has also served as professor in charge of Law Center till last year and is joint director of Delhi School of Public Policy and Governance. Sir is also a very, very famous name in lecture circuit and has delivered lectures in various prestigious institutions, including World Intellectual Property Right Organization. Thank you so much, sir, for joining us today and taking out time. The virtual floor is yours.
Thank you, Kathy. Honorable Mr. Justice Rajiv Shakhter, the chief guest, our guest of honor, Mr. Vinod Kumar and Mr. John Kabeka, all participants, my friends, faculty members and students, a very good morning. Time is of essence in IPR disputes, as all IPRs are limited in time except for trademarks and geographical indications. The Commercial Courts, Commercial Division and Commercial Appellate Division of High Courts Act 2015 of India was amended in 2018. The 2018 amendment provided mandatory pre-institution mediation and settlement in commercial disputes, including IPR disputes. Now, the IPR disputes may get disposed of in a time-bound manner, provided both the parties come forward with an open mind with the intention of resolving them. The mediation has been successful in other countries in the resolution of IPR disputes. It is prevalent in Philippines. It is there in the United States also. The WIPO Center for Mediation is also providing service of mediation through WIPO mediation rules of 2016. As of 2018, WIPO Center has administered more than 560 cases worth several $100 million from more than 60 countries. Now that is something which is a very good signal. And that tell us, about the future of mediation in resolving IPR disputes. With these words, I welcome Chairperson of the session, Honorable Mr. Justice Rajiv Shakhter, Judge, Delhi High Court. I'm delighted to inform that Honorable Lordship is worthy alumnus of Law Center 2, University of Delhi. Lordship has also completed Chartered Accountancy course. Lordship pursued advanced course of law at the Institute of Advanced Legal Studies from University of London in 1994. Lordship was enrolled as advocate in 1987 and designated as senior advocate on 8th of December 2005. Lordship has vast experience in civil litigation, constitutional law, with a special emphasis on commercial litigation, corporate and taxation laws. Lordship practiced in the Supreme Court, various high courts, tax tribunals, MRTP and Company Law Board, and many other forums. Lordship was appointed as a counsel for the Union of India and senior standing counsel for the Office of Comptroller and Auditor General. Lordship was appointed as additional judge of Delhi High Court in 2008. He became permanent judge in 2011. We welcome you, Lordship, once again.
Thank you.
I also welcome our guest of honor, Shri Vinod Kumar. Shri Vinod Kumar started his career in international collaboration and projects in 1989. He is currently the honorary president at the India SME Forum. He advises various government agencies and institutions to strategize and deal with current issues and future challenges with respect to SMEs. Mr. Vinod was nominated as a member of India's Central Bank, the Reserve Bank of India's Standing Advisory Committee on Flow of Institutional Credit to MSME sector. He is also a nominated member of the Advisory Committee of the Ministry of MSME as well as the High-Powered Monitoring Committee under National Scheduled Caste and Scheduled Tribe Hub under Stand Up India of the Ministry of Micro, Small and Medium Enterprises of the Government of India. Mr. Vinod has achieved many milestones, and it is really very difficult to give a true picture of his achievements in a very short span of time. I welcome you, sir. I also welcome our second guest of honor, Mr. John Quebeca. Mr. John is a US intellectual property counselor for South Asia, serving Afghanistan, Bangladesh, Bhutan, India, Maldives, Nepal, Pakistan, and Sri Lanka. Working through the United States Embassy in Delhi, Mr. John is the principal officer within the US embassies and consulates throughout South Asia on matters related to the protection and enforcement of IP rights. His duties include assisting US companies doing business in the region, advocating for effective IP policies, advising ambassadors and the other US government officials on foreign governments' IP practices, educating foreign government officials, students, startups, and business representatives on the IP landscape, and conducting public awareness programs to support a strong and vibrant IP system globally. Mr. John has also worked at the US Patent and Trademark Office USPTO for more than 30 years in senior capacities. Mr. John also served on a special assignment to the Executive Board of the President in the United States Trade Representative's Office, that is USTR, where he worked on international intellectual property rights and enforcement priorities for USTR's Office for Intellectual Property and the Office for Japan, Korea, and Asia Pacific Economic Cooperation Forum Affairs. In 2019, Mr. John was recognized by the head of the US Office of Personnel Management for his leadership role as chair of the San Francisco Federal Executive Board and for his service to the nearly 50,000 federal employees working in over 450 agencies and offices across Northern California. With these words, I welcome you, sir, and I welcome all the guests today and the participants to this particular session. Thank you.
Thank you, sir. I would now like to request Vinod, sir, to address the virtual gathering. So the virtual floor is yours.
Thank you. Thank you very much, Kathy. Honorable Mr. Justice Rajiv Shakdar, Professor Dr. V.K. Ahuja, Mr. John Quebeca, Dr. Ashutosh Mishra, and friends from the legal and intellectual property profession. It's a pleasure to be here today. I represent small and medium entrepreneurs in India, and we have close to 86,000 members that are from the small and medium ecosystem. Now, when we talk about disputes relating to intellectual property protection, we have seen a gradual escalation in the Indian legal setting. Intellectual property protection is available for a limited period for intellectual property creators who have to enforce it in an effective manner. Because of the excessive delays in the judicial system, there's need to look for other solutions and mechanisms for sharing the burden. This is particularly relevant because the aggrieved person normally enjoys limited rights and only limited remedies available, which is prescribed under substantial legislations. Now, alternative dispute resolution measures are gaining prominence for enforcing the protection of intellectual property. Now there, with 86,000 members from the small and medium enterprise community, we have been constantly arguing for alternative dispute resolution mechanisms for solving all commercial disputes. Similarly, when we talk about intellectual efforts of the creators of intellectual property, now these are valued on the basis of the sign of the rights affixed to the intellectual output. Now, when we talk about protection, it provides a pointer to the creator to exert his powers over third parties who, without his permission, try to use the fruits of his labor. The rationale for creation of rights gets defeated if they cannot be enforced. And the owners of intellectual property have to be their own watchdogs and take recourse to the courts whenever there is an infringement. The Indian courts have taken a giant leap towards the development of the IPR regime in India. However, when we are talking about available resources that we have, we could put them to better and proper use if an alternate dispute resolution mechanism is constantly deployed. Now, when we talk about matters related to patent law, copyright law, these involve an intersection with science and an understanding of technology. These need special educating officers who can comprehend the interdisciplinary nature of the case at hand, and they should have sufficient ease in dealing with the matter. Now, when we talk about the limited nature of protection that can be given to the owner of intellectual property rights, this calls for mechanisms, developing mechanisms that primarily can execute immediate and swift justice. Now, within its garb, within the garb of ADRs or alternate dispute resolution, there are multiple mechanisms which are provided by the traditional model. And when we talk about the Arbitration Conciliation Act 1996, that has been the main statute in India dealing with the two-sided, alternate forms of dispute resolution. The Civil Procedure Code 1908 also provides for adoption of different models for the expeditious determination of disputes. The merits of the modes of alternate dispute resolution are not only limited to speedy remedy, but also to the flexibility, cost effectiveness, confidentiality, and business-oriented results. Now, we've been talking about how effectively the Indian judiciary has been trying to bring mediation and settlement for intellectual property disputes in the traditional model. Now, if we go to do a reading of Section 89 of the Civil Procedure Code 1908, even where alternative dispute resolution methods fail to be the effective choice for determination of disputes related to intellectual property rights, they can be used for narrowing down the issues for contestability in a traditional model of litigation. And I feel that the alternate dispute resolution measures or mechanisms for intellectual property are the need of the hour. They are less time consuming, efficient, and can provide flexibility to the rights holder. And while we are saying that, it's important to note that in all commercial transactions, the route of alternate dispute litigation has already shown its majority over traditional modes. Nowadays, contracts which are basically about transfer of intellectual property, they normally include, as an organization, as an association, we've been pushing that there should be an arbitration mediation clause in all the contracts that are put in place. Now, infringement of these intellectual property in law, in legal terms, is in personam, as it determines the rights between two parties and can certainly be educated by the use of ADRs or the alternate dispute resolution machinery. Now, similarly, when we come to patent laws, now that channelizes the field of technology. Now, when we are looking at understanding of technical knowledge related to the dispute in question, the biggest hurdle which most Indian courts face is with respect to streamlining the trial of the dispute in a cost-effective and prompt manner. Every dispute in the domain of patent law has revolved around the nitty-gritty of injunctions, stays, and appeals related to those injunctions. And in fact, a lot of countries have endorsed the inclusion of arbitration as a model for resolution of patent disputes. Now, this closer integration of ADR in patent infringement suits could be the way forward for appropriate dispensation when it comes to justice. Similarly, when we talk about trademarks, overtly trademark litigation is again an inter-party dispute. Alternate modes of dispute resolution can definitely provide an appropriate recourse. And it is Also here that I can talk about the Uniform Domain Name Dispute Resolution Policy 1999 and the Indian Domain Name Dispute Resolution Policy, which looks at cases of cyber squatting and so on and so forth in terms of domain names and the other things. In conclusion, what I'd like to say is statutory rights, which are limited in nature, they solicit a different approach for their effective enforcement. The jurisprudence related to the establishment of various quasi-judicial bodies under different property laws, intellectual property laws, points out that these bodies were formed to share the load and to render an expert testimony towards the determination of validity of the intellectual property in question. This infringement of intellectual property rights, because it pertains to inter-party dispute, can definitely and should be educated by using alternate dispute mechanisms. We're talking about an Atmanirbhar Bharat, which has to have a flourishing ecosystem for entrepreneurship, which has to primarily be the forebearer of job creation in India. And we would, I would reiterate that this ADRs, primarily in commercial and all industrial disputes, would be the biggest enabler for an Atmanirbhar Bharat. Thank you very much.
Thank you so much, sir, for your session and for reiterating the importance of mediation and ADR mechanisms in IPR disputes, where the need is of immediate and swift justice, confidentiality, and cost-effective manners, and the need of effective inclusion of ADR in commercial matters. Moving forward, I would like to invite John Cabeca, sir, to address the session.
Okay, good morning still. Can everyone hear me?
Yes, sir.
Okay, wonderful. Thank you very much for inviting me to join this program and this very important topic. I also want to start out by wishing everybody a very happy World Intellectual Property Day. So World IP Day takes place every year on April 26th. And in the days around World IP Day, we like to celebrate and recognize the spirit of World IP Day as it is and its theme, which changes every year. This year's theme is focused on the small business and early stage entrepreneurs and startups. The theme is IP and SMEs, taking your ideas to market. And if I may, I would just like to share a very quick slide. Let me see if I'm able to do this effectively. Let's see here. One moment to see if I can just share my screen. Yes, okay. And so this is, hopefully you can see this. This is a slide that I've used in many presentations when I was the USPTO's director for our Western region in the country based in Silicon Valley, when we work really closely with startups and just trying to give them an idea that there's many aspects to innovation and protecting those innovations. And it's all part of this broader cycle. So when I was thinking about today's program and thinking, where does mediation come into play here? And in what role does mediation play in this cycle of innovation? And to me, it doesn't deserve just a circle by itself in this cycle, because it does touch many different aspects of the cycle, as you can see here. And I just think that it's relevant. And there may be other circles here, other activities within the cycle of innovation where where mediation may come into play. And so I just wanted to share that because I think it's a nice graphical image anyway of how important the role of mediation plays when dealing with intellectual property. And so in thinking about this further, in understanding our IP system, that our IP systems, regardless of where you are in the world, were really designed to create a variety of different mechanisms to ensure that all aspects of innovations and creations are protected. And so it's not a one size fits all scenario. And through these variety of mechanisms, we aim to secure IP protections for all of these creations and innovations. So wouldn't it just make sense that there would also be a variety of mechanisms with which we can enforce those rights and protect those rights? And whether it be through the courts or through ADR mechanisms or through just normal business deals, we can secure our rights and ensure that IP is protected in the best way that it can be. And that's one of the nice things I think about intellectual property is once you have the right, you get to set the terms, and obviously someone has to agree to those terms, but you get to set any terms that you would like, or at least try to, in order to create agreements, licenses, settlements with respect to how those rights are used. So it reminds me of a story, and if I may, I'll just share it briefly. I had the opportunity when I was in Silicon Valley to meet the CEO of a very, very large, I won't say who, very large company, a global company. And I asked her, I said, when you are in the boardroom and you're surrounded by all of these C-suite executives at the table, how does IP come to play in those boardroom discussions? And what did you need to hear when it came to deciding whether or not to pursue any sort of, whether to protect or enforce intellectual property? And so it was interesting because she lit up and she told this wonderful story, which I'll share now. She said when she first became CEO of this company, her legal team came in with boxes and boxes of papers and dropped them on her desk. And this was, I believe, around $1 billion lawsuit that had been ongoing for over a decade. And there was some specific court action that needed to be taking place in the near future. And they wanted her buy-in, sign here on the line so we can spend this money and pursue this litigation. And she said, well, hold on a minute. What have we done, over the past 10 years? What have we tried to do to work it out with our major competitor that we believe might be infringing these rights? And they said, well, they've been working it out between the legal teams. And she's like, give me a minute. And she goes and she picks up the phone and she calls the CEO of the other company. And she says, why are we doing this to ourselves? We're spending millions and millions of our revenue that could be going back into research and development to be furthering our innovations. Instead, we're focusing on attacking each other on this case. We have to come to some sort of agreement never to let that happen again. And for the case that was actually before her, had been so far down the road, they agreed to let it play out in the courts. But then they said the next time either one of their legal teams come to them, they had agreed to pick up the phone and call each other first and have a dialogue. So what ended up happening was just a few months later, her legal team came in and said, we need to take this legal action against our competitor. And she said, let me honor my agreement and call him first. So she picked up the phone, she called him and she said, this is what my legal team is telling me. They want to file this today in court. And I wanted to give you an opportunity to look at the issue and respond. And so he met with his legal team, called her back, said, we had it, it's our bad, we were wrong, it's our fault. Our legal team is contacting your legal team and we're working it out. And through this dialogue and through the years that she was a CEO, even though she's now retired, they had eventually agreed to meet every quarter. And the funny thing is, since they're large global companies, she said, I would meet in his airplane hangar or he would meet in my airplane hangar once a quarter. We would touch base and talk about all of the issues that each of our companies were facing with respect to our intellectual property. And as a result of that, they were able to reduce their litigation costs by over 85% in working it out as adults, as we like to say. And so I think that's a really ideal story. I think there's a lot that can be said there, and the power of intellectual property is she would have never been able to, or the competitor would have never picked up the phone to even talk to her if she didn't already have a strong foundation of intellectual property. So acquiring the IP rights is critically important, ensuring that those IP rights are of the proper scope, that they're going to give you the protection that you need, so that when you need to make that call, someone picks up the phone because they know that it's important and it's very.
John, we seem to have lost you.
Very difficult, intellectual property within the court systems with which for other scenarios to play out. And you've heard, am I audible?
Yes, yes, you are.
Okay,
Fine.
I'm going to go off camera because I'm getting some bandwidth warnings. So if you can't hear me, let me know. I'm actually signed in separately on another device, so I can switch.
Cool.
Okay. Thank you for that. I've been having a lot of connectivity issues today. My internet has gone down several times. So thank you for your patience. So I'd like to share that story. Hopefully it's meaningful to you as it is to me. And really just, I think, underscores the power of intellectual property, the power of dialogue, and through mediation as well when needed. I'd like to take a moment now to talk about my role here in India and as the IP counselor for South Asia for the US, and the role that we play and the reason that we're here. There are actually only, we're part of the Intellectual Property Attaché program. There's about 14 of us around the globe. And our primary role is to work on advocating on improving IP policies, laws, and regulations. We work to raise issues with foreign government officials. We work to gather stakeholder input, whether it be through direct industry engagement, or through their organizations. We provide training on IP law enforcement and the administration of these laws, in addition to conducting numerous public awareness programs. On IP policy, we promote intellectual property policy internationally, helping to secure high standards in IP agreements and including supporting and providing feedback on host countries' efforts to improve their laws and regulations. We encourage effective IP protection and enforcement, and we work with disseminating information to the public. And when I talk about dissemination of information, it's also within our respective intellectual property offices where we can share best practices with each other, but then also through public awareness programs. Our public awareness programs are quite extensive, and today is a good example of them. They're at all levels.
John, use your other device. We've lost you again.
Okay, can you hear me now?
Yes.
I'm sorry, can you hear me now?
Yes, yes, we can, John. Please go ahead.
Okay, thank you. Yes, that was perfect timing because my other network just went down. So apologies again for that. I will try to be brief. I did just want to highlight when it comes to legal programs, we've provided sessions in the past working with universities on specific legal matters, issues that the stakeholders have in obtaining their IP rights here in India specifically, and then also judicial programs and sharing best practices with the judiciary and on updates within our own legal systems. So I believe that a lot of the focus on mediation has already been addressed, but I do think it's important to mention that the trend of using mediation, much like I believe the example I gave earlier, is going to continue to increase as globalization and global marketplaces continue to expand, and as it becomes more and more challenging to pursue remedies through court systems around the world. And, and so basically giving you the opportunity and option through ADR to preserve, having to fight these battles in court for only those cases where they cannot be resolved through other mechanisms, through ADR or other types of dialogue. And with respect to ADR and including mediation, there's definitely many advantages over the traditional litigation method. As I've mentioned, you have the ability to maintain some confidentiality. You can agree to have a certain core of experts to help decide the matter. It's a single procedure instead of multiple parallel and serial litigation tactics that could possibly be employed. And it's a way to obviate the need to pursue those tactics. And it could really result in a very speedy settlement without damage to the parties or the party's reputation, as many times those settlements can be maintained confidential, as I mentioned. Some other advantages, it gives you the ability to control the dialogue of what's taking place during the mediation. It's flexible as it is because it is intellectual property with respect to its terms and the remedies that you might be seeking. I mentioned that it's also can be expedited, but also it's a cost-saving mechanism in addition to being a procedure that can take place in less time perhaps than litigation. It also gives you the ability to save the cost of litigation and perhaps put some of those resources either back into R&D or into the settlement, whichever the case may be. Some concerns, though, that I've heard anecdotally with respect to mediation is it can also be unstructured. There's also some uncertainty with respect to how it may play out, and the procedure itself, may be non-binding. Settlement is at stake. That's the ultimate goal through the mediation effort. But ultimately, we can, the procedures itself, if not clearly identified at the outset, could be problematic throughout the mediation. At the USPTO, we have many alternative ways. I'm sorry, in the United States, we also have many alternate ways of settling disputes. Much like here in India, through the courts, court-ordered mediations or court-ordered arbitrations, and things along those lines. But I thought it would take a moment to share from the USPTO, because we do get asked a lot, because we have our own tribunals within the US Patent and Trademark Office for opposition proceedings before the Patent Trial and Appeal Board and the Trademark Trial and Appeal Board, where we have a cadre of tribunal judges that oversee the opposition proceedings for their respective patent and trademark issues before them. And while our judges do not get involved in mediating the disputes between the two parties, they rely they rely solely on the factual evidence that has been provided through the opposition. They do engage in conferences, in hearing conferences to take place and help them adjudicate the matter. And they do also inquire through the proceeding whether or not the parties have sought some form of dispute resolution mechanism. And in some cases, they may encourage that. If they haven't, they may wish to pursue that. But as far as getting involved in the matter themselves, they are a separate entity and do not get involved in arbitration mediation matters, but do want to know if that has been something that was pursued prior to the opposition before them. One other point I thought I would also raise is that the World Intellectual Property Organization also provides alternative dispute resolution services, and they have a cadre of experts around the world that might be able to assist in these matters for rights holders. So as we conclude here, I just wanted to take a moment to just again highlight, that the most important thing when it comes to mediation is to decide, when is the appropriate time to actually pursue mediation. And as I've heard from stakeholders I've worked with throughout the years, there's definitely an effort to try to preserve the ongoing relationship between the parties, if not to try to strengthen it, as I mentioned in my example earlier at the outset of this talk. And especially since the matter involves monetary damages rather than liability, that goes into your risk assessment as to whether or not to pursue mediation. Obviously, when it comes to these monetary damages, the stakes are very high, and they are at odds with whether or not to pursue this mediation in view of litigation, but also recognizing that litigation has their own obstacles, and so that, again, goes into that risk assessment as to whether or not to pursue the mediation strategy. And then the other advantage here is that these disputes, as I mentioned, can really have a creative solution, one that is, through the mediation process and kind of the inherency of the mediation process to create what works best for both parties. And so I look forward today to joining the discussion. And again, thank you very much for inviting us to participate in today's program. I look forward to hearing the other panelists. And again, thank you very much for being here, and happy World IP Day to everyone. I'll conclude my remarks and turn it back over to the moderator. Thank you.
Thank you so much, sir, for joining us and for throwing light on the importance of mediation and cycle of innovation, for reiterating how mediation provides a safe space for dialogue, which more often than not is the best way to go forward in a dispute, for elaborating on the role or on your role as IP counselor for South Asia and the United States, and for elaborating on advantages and concerns for the process of mediation. Moving forward, I would now like to invite the chair for the session, Honorable Mr. Justice Rajiv Shakdher of Delhi High Court, to address the virtual gathering.
Thank you so much. Professor Ahuja, Professor Ashutosh Mishra, Mr. Vinod Kumar, Mr. John Kabeka, dear students, ladies and gentlemen. We couldn't have had a conference on IPR at a more appropriate time when the country is going through COVID crisis, and I'll come to that point a little later as to why it has attained criticality in today's environment, time, and space. Insofar as India is concerned, it has had a culture of mediation for a very long time. If one were to go by our epics, this is as old as 5,000 years old, when Lord Krishna tried to intervene and mediate between Kauravas and Pandavas. So we've had a culture of having panchayats in villages, taluks, which very effectively mediate on disputes concerning individuals. Insofar as today's world is concerned, mediation again is not very new. It sort of commenced in 19th century, gained traction, so to speak, in the 20th century. Now, mediation, as my co-panelists have spoken most eloquently, is part of an alternate dispute resolution mechanism. It, in a sense, combines well with conciliation and arbitration, which are also well-known methods of intervening and settling disputes. As we all know, that mediation has taken center stage, or other ADR mechanisms have taken center stage, because of the dissatisfaction that litigants have expressed, especially in India, and I'm sure this is world over because it's a world over phenomenon, with the traditional court-driven manner of settling contentious disputes. The reasons are not different than that which trouble courts in India. There are delays, there are exorbitant costs. And finally, it appears there is unhappiness with the result that is achieved. Sometimes even by the winning party, because he doesn't get the complete cake, he gets part of the pie or the cake. So the advantages of mediation are well known. My co-panelists spoke. And to just give them in a bullet form, these are basically, and these are empowering, I would say, attributes of mediation, which is partly autonomy, simplicity, flexibility, and finality. Finality is something so important for a litigant because it actually takes the dispute out of the stream of the adjudicatory process. And that stream can flow, as I said a while ago, in some jurisdiction for a decade or more. Now, despite all these advantages, I've often asked myself the question, and especially in the context of intellectual property rights, as to why it has not gained the kind of traction that perhaps it has attained in other areas of disputes, civil disputes especially. Although I must say that there are some organizations like WIPO, to which reference was made in the opening remarks of Professor Ahuja, they have achieved a healthy conflict resolution rate. So I was reading through the report, and I think Professor Ahuja was referring to the same report, where WIPO has indicated that it managed, or its mediators managed to resolve 70% of the disputes referred to them. The report also is suggestive of the fact that, in fact, arbitration disputes were also settled through mediation, and the percentage given is nearly 30%. As a matter of fact, what is more heartening is, in the very same report, that in 2020, which has been the most difficult period for the world, the percentage of resolution has gone up to 78%, about 8% above what it was reporting earlier. Closer home, the Delhi High Court Mediation and Conciliation Center. I had the statistics taken out, which shows that between 1st of April 2019 and 31st March 2020, that is before the pandemic hit the world or our country, where we went into a lockdown, 725 cases were referred, out of which, no, the figure is the other way around. It is actually 725 cases were resolved, out of which 83 pertain to IPR. So 11% of the resolutions were in the area of IPR. For 2020, which is 1st April 2020 to March of 2021, the resolution of IPR cases out of the total cases resolved by the Delhi High Court Mediation Conciliation Center, the rate rose to 30%. So it appears that during this period, the more critical period, as I just spoke about, 30%, the reference was perhaps higher and the resolutions were higher So the comfort that I take from this is because there was a problem in accessing courts, though I must say courts have remained open, we work virtually. Parties tended to go to mediation centers and have their disputes resolved, which makes me optimistic that if this culture, which is very old in India, is given a greater fillip, and policymakers have to think as to how incentives and fillips have to be given, there is a possibility of these disputes getting resolved. And we are talking about IPR disputes getting resolved through mediation. Now, I compared this, the Samadhan figures, with figures of the Delhi Mediation Center, which is basically dealing with disputes referred to them at the district court level. Now, their strike rate for the same period, 1st April 2019 to March 2020, was 15%. And between April of 2020 and 31st March 2021, it was about 38%. Now, the problem is the strike rate is good, the reference is less. The number of cases which are referred is very, very minuscule. There could be several reasons. One of the reasons is obviously that the more high value disputes in IPR and by companies who can afford to pay a higher court fee, and then the lawyers creatively show pecuniary jurisdiction at a higher value because of they wanting to come to the High Court. We have larger number of cases in High Court, and therefore references perhaps larger. But in terms of ability to have them settled is no less in the Delhi Mediation Center as compared to what we have in Samadhan. Both institutions have mediators of high quality. What they perhaps lack is enough references to the center, and perhaps not being able to persuade litigating parties to come to the center. If that could change, I think the IPR environment in mediation would change. The hesitancy syndrome, as I call it, as to why there is to refer disputes to mediation in IPR are well known. To articulate a few, there is always this latent suspicion of mediation being unstructured. Not true, but that's what they are given to believe, or that's what hardcore litigating lawyers believe. Then the uncertainty as to how they are going to mediate with regard to damages. It appears, and we find from actions, that plaintiffs who come to court seeking adjudication of their rights are not able to pin down, and sometimes rightly so, as to what will be the quantum of damages that should come to them. And similarly, the defendants don't know as to how much they have to pay. So that uncertainty, which lawyers and litigating parties don't like, prevents them perhaps to approach mediation centers for adjudication of dispute. The third, I think, the more important reason is that sometimes parties who have IPR rights in their favor, intellectual property rights in their favor, want, in public interest, a public adjudication of their rights. Right? Why? Because they don't want another infringer coming in and doing the same thing. They may settle with one, then the other fellow comes in. So they want a precedent to block others. Now that is a concern that we need to address. So therefore, when we propagate mediation, what we need to do is to concentrate on the obvious benefits of mediation. Speed, number one. Second, you have the ability to go to a neutral expert as a mediator. Now, I can tell you as a judge, and something that I must share is that in IPR, there are such a variety of rights that come for adjudication. It is impossible for the judge to know of every such area. So there is an element of delay, not deliberate, but because of unfamiliarity with the terrain that the judge is dealing with. The unfamiliarity is also evident in the lawyers. Now, lawyers are trained to interpret a statute. They're trained to, in a sense, ferret out evidence from witnesses of opposing parties or to present evidence and to present that evidence before an adjudicatory authority, which ordinarily would be a court, or when there were tribunals, the tribunals, which of course now with the ordinance they have been disrupted. So if you're dealing one day with a dispute involving telecommunications, the other day and the next day you're dealing with a dispute involving patent in a drug, these are two different fields altogether. But what you get in mediation is, and that is what needs to be promoted is neutral experts. And when I say experts, domain experts for that particular industry. So what mediation centers don't have, at least in India, I don't know abroad what's the, how's the panel constituted, is to have domain experts as mediators with training in mediation for various industries. If that happens, then perhaps a serious attempt can be made at having these disputes resolved and having parties go there and tell the competing or a party or the violator, the defendant, that this is what we need to focus on, because otherwise mediation can go on too long, and that is one of the reasons why people don't go to mediation, because they feel that this is only a tactics to delay my action. Which brings me to what Professor Ahuja touched upon in the beginning, and which is a very, very constructive move that the legislators made, is the introduction of Section 12 capital A in the Commercial Courts Act. Now, while it mandates pre-institution mediation, it, in a sense, is not working. Why? Because the exception is that if you seek interim relief, you need not mandatorily go through a 12-way process. You will find in every IPR action, there is an interlocutory application. Whether it is viable, it is not viable, in a patent action, infringement action, even if the defendant has already started manufacturing the drug, they still come to court and seek an injunction. Not being realistic enough that if the infringer, the alleged infringer, has already started using the patent, the likelihood of an ex parte injunction is diminished, and you may end up taking the same amount of time or more time in being in court rather than going to a mediator and having your dispute settled, because you have several opportunities of having it settled. You can have it licensed. You can, confine the use of the defendant in a particular territory where the defendant is dominant. So there are several possibilities, but they don't do it, and that is one of the biggest, let's say, kink in the flaw in Section 12. The other, of course, is a more larger picture, because people who are pure mediators or who believe in mediation say that compulsion is antithetical to mediation. Mediation is a voluntary activity where I should be able to decide whether I want to go through the mediation process. And this ties up with my point where someone says that I need in public interest, a public adjudication of my rights. So it is time that we think as to how to carry it forward. Now, like many other countries, we have introduced provisions for mediation and conciliation, several statutes. It's in Section 18. It's not mediation, it's conciliation in most statutes. Section 18 of the MSME Act, as Mr. Vinod Kumar would know. It's also in statutes which involve, personal rights. We've done it in the Hindu Marriage Act, not concerned with us, but Special Marriage Act, etc., and RERA as well. Of course, in the conciliation in the Industrial Disputes Act. But is the time right now to have a separate act for mediation, where policymakers will dovetail a lot of these, concerns into one statute and provide for a mechanism where people are encouraged to avail of mediation? It's a very, very strong and robust ADR mechanism which needs to be encouraged. In fact, I have been heading the arbitration committee in the Delhi High Court, not now, but some while ago. And one of the things that we tried to introduce there was to have a pre-arbitration mediation as well as post-arbitration mediation. So perhaps if you have a separate act, you could also introduce a provision which I think should be sort of incorporated, is even if a matter goes for adjudication to a court, the court can or should be able to give a preliminary view on what he thinks could be the verdict in a case. It's a preliminary view. And then when it becomes more realistic, the plaintiff or the defendant realizes where he stands, and then if you send them for mediation, the chances of a settlement coming through are higher. I mean, without a statute, as a judge, one has tried this. Where you hear a party for a period of time and you tell them, listen, tell the lawyers, this is where I broadly think, your case lies. You tell the plaintiff or the defendant, I think this A is achievable, B is not achievable, unless you persuade me to the contrary. You people need to sit on the table and concentrate on this core issue where you can perhaps arrive at a settlement. So therefore, what I'm trying to suggest is whether it's arbitration or a suit action, you can and should be able to encourage mediation even at that stage. Nothing is a lost cause, but if you have a settlement, that one case goes out of the stream and helps you to if nothing else, bring about a lot of happiness. So, since we are running short of time, one of the last things that I want to touch upon, there are several other things that I want to do, but one of the last things that I touch upon, because I started by saying that we are in pandemic. I was reading this news report where USA has said that US citizens come first. They are not going to export raw material to India for manufacture of drugs. Germany, Mrs. Merkel has made a statement that if India, as it has taken a decision because of the present crisis, to calibrate the exports to other countries, then they will rethink as to whether they will continue to engage with India, because it appears that the news report gives that impression that this vaccine which was manufactured here was done with the intent that it will be exported to other countries. I'm talking about the AstraZeneca vaccine, which is the Covishield vaccine. Now, and the strange part is that India has asked for the TRIPS waiver agreement. As we all know, TRIPS ensures that WTO members, if they are signatories, they have to ensure that patents are granted and enforced in India. Now, India and 8 other countries have approached WTO for waiver of the agreement for drugs, for ventilators, for diagnostic equipment and other medical equipment which are required for COVID-19. I read a report as recent as yesterday where Europe and US has indicated that, while we understand the crisis that India is facing, a complete waiver is not the way out. So therefore, what are the options? The options under our statutes are compulsory licensing, which won't work for a reason that the virus is mutating. So a drug which is efficacious today may not be efficacious tomorrow, and the research for the same is happening in Europe and US, because whether we like it or not, they have the money to finance this research. And therefore, when there are variants, they may be able to give us a drug which can protect, possibly, I don't know, none of us have an answer, even scientists don't seem to be having an answer, to protect people all over the world. Now, therefore, the only way of engaging is perhaps a mediation at an international level, where you mediate with a manufacturer, say, listen, I know you want something in return for the investment you've made. This is what I can offer you by way of price or by way of other benefits, maybe some future agreements. The government may say we may buy drugs for other disease. I'm sure the experts can think out of box and offer that. So therefore, to my mind, and to add to this report, what I read was very heartening, because I read a report today of an interview with Dr. Weizmann, who along with Dr. Catty was responsible in the R&D that went into the Pfizer BioNTech drug, and they discovered what is known as a modified RNA with liquefied nanoparticles. That Moderna, which is the beneficiary of this research, has actually said that we are not going to claim IP rights for this drug. Can we intercede with countries, with manufacturers like Pfizer, and get them to agree to the same? If we can't get a complete waiver on IP rights, we may get some other resolution. So, as I said at the beginning, and with that I conclude that this conference couldn't have come at a better time, but this conference should be taken forward and discuss IPR in the context of COVID-19, which has hit the world so badly that one doesn't know how to get out of this problem. So thank you very much, and God bless you. I have overshot a little, but helped.
Thank
Yes.
you. Thank you so much, Your Lordship, for delivering a rather data-driven session while connecting it with how mediation is in our culture, for going in depth with the hesitant syndrome and emphasizing on the need of incentivizing the entire area of ADR and importantly mediation, while concluding on the note of how mediation can actually provide a way forward in times of COVID. Thank you so much. Now I would like to invite Professor Dr. V.K. Ahuja sir to deliver a vote of thanks.
Yeah, am I audible?
Yes, sir.
Yeah, thank you, Khyati. Thank you, Your Lordship, for raising very pertinent questions. The flaws, the reasons which you have pointed out to why mediation had not picked up, these are very important. And I think that there is a need to do more study on that. And maybe that the academia and the judiciary can have some more programs, can have more studies on this particular aspect. And we can just find out the answer to the questions which you have raised as to why mediation had not picked up in the IPR cases. There is one more thing, I totally agree with you that we need to have a codified law because the guidelines, I think, may not work well, actually, so far as mediation is concerned. There is an issue with respect to the integrity of the mediator. Now, you do not have any such law, basically, which talks about that. Of course, the guidelines are there. So unless we have a codified law, maybe that mediation will not pick up to the level to our expectations, actually. And then there is one more thing which I just pointed out, which I would like to bring to your notice. And I think John Quebeca had also pointed out that what happens is that in many of the litigations in IPR, because the economic worth is very high, actually. So there are a lot of settlements which happen during the litigations, and there are out-of-court settlements also. So mediation is one thing, when the mediation has been initiated. So there are more possibility, and what have been experienced is that there are more settlements which are taking place during the course of mediation. So this is something a win-win situation for both the parties. With this observation, Your Lordship, we have now come to the end of this session. And on behalf of Law Center 2, Ministry of Law and Justice, Samadhan, Delhi High Court, and Delhi School of Public Policy and Governance, the Institution of Eminence, University of Delhi, I thank Honorable Lordship for enlightening us on the topic of mediation in IPR cases and raising the problem, which India is facing today. Thank you, Lordship, and I know that you have been very kind to Law Center 2. You are always obliging us. Keep on blessing us in future also. Thank you, Lordship. I'm also thankful to Mr. Vinod Kumar. Sir, I know that the 15 minutes time was not sufficient, for your presentation. And you are also very kind to Law Center 2. You were there along with the Lordship, in our first international conference on mediation. Please keep on gracing our occasions in future also.
Be my pleasure.
I'm also thankful to John Quebeca for putting forward his views on this contemporary topic. So John had joined us for the very first time. Sir, we are really thankful to you and the story which you shared with us. And I hope that in future programs, you will be kind enough to grace the occasions. Thank you, sir. I'm also thankful to Professor Mahavir Singh, the PIC of Law Center 2, Professor M.K. Pandit, the CEO of the Institution of Eminence, Dr. Ashutosh Mishra, the Conference Director, all my colleagues, Dr. Ashutosh Acharya, Dr. Rajay Sonafne, and Khyati, and all the participants for being with us. Thank you very much. Namaskar.
Thank you very much, sir, and thank you to our esteemed panelists. I would like to take this opportunity to extend felicitations to Dr. Ahuja, sir, for his appointment as new Vice Chancellor of National Law University, Assam and Judicial Academy.
Thank you.
On
Yes,
concluding,
congratulations, sir.
Thank you, sir. Thank you, sir. Thank you.
Congratulations, Professor Ahuja.
Thank you, sir. Thank you, Lordship. Thank you.
on concluding note, I would request the participants to check the chat box and fill the feedback form, the link for which has been circulated. It is mandatory to qualify for the certificate. Thank you so much, everyone, for joining us today. Stay safe.
Thank you.
Thank you very much, Lordship. It was really enlightening to listen to.
Thank you. Kind. You're very kind and